Good evening, everyone. My name is Adrieannette Ciccone, and tonight I have the pleasure of introducing the illustrious civil rights champion, attorney, activist, icon, Mr. John Burris. He will be talking to us this evening about racial bias and obstacles in selecting and litigating police cases. Mr. Burris is our first African-American recipient of the Litigation Section's Trial Lawyer Hall of Fame Award, and we're very, very happy about that. We were happy that we were able to award Mr. Burris the award this year. Mr. Burris has been practicing law for a long period of time, and I won't give the exact number of years, but just know that he graduated from, I'm sorry?
No shame.
No shame, okay. Mr. Burris graduated from UC Berkeley School of Law, and he represented Rodney King in the 90s, and he's represented Oscar Grant's family and countless other people who unfortunately have been victims of excessive force and police brutality. And Mr. Burris, we are so lucky to have you. So with that, it's 5:31. We want to be respectful of everyone's time, and thank you all for coming, but we can get going.
Well, thank you. It is certainly my pleasure to be here. I have been involved in this form of litigation for a long time. Just by way of background, I did start off in a firm in Chicago. I did do the state's attorney's office as a prosecutor in Chicago, and then I was a prosecutor in Alameda County. And I know people say, how in the hell do you get to do this work and you start out as a prosecutor? It's a question that I answer often. And I'd say it's easy because you're representing victims all the time. But after a period of criminal defense work, this has really become my life's work in the last 35 years, essentially representing plaintiffs in police misconduct cases. I have literally run the gamut of police cases that one can imagine for many, many years. I feel that I've represented probably over 1,000 people in different cases, and some of which you would never hear, but a lot of them are well known. I've been involved in a lot of high visibility cases. But at the end of the day, it's still about trying to bring out a result for a client who comes to my office, tell their story, let people know that these cases are not something that you'd read about, but they're real live people here, and people who are suffering, and people who are dead, that in my view shouldn't be dead. And I'm always trying to bring their story to life. And that's probably my most important aspect of here, is telling the story of people who otherwise couldn't tell their stories for themselves. And so that has required me to be really in the forefront of litigation in this area for a long time. So why don't we start? The title of this is Racial Bias, Obstacles in Selecting and Litigating Police Cases. This is a title that of the presentation I had made a while ago, but actually it brings on different kind of meanings perhaps now that the more attention is being given to these cases, with George Floyd certainly being the case that is at the forefront. But in the last 2 years, I've tried several police cases. I just finished one right before the virus hit. I tried a case involving a young man who was shot and killed by BART police. Earlier this latter part of last year, I tried a case against the Stockton Police Department. And a couple years before that, I tried a case against the San Jose Police. Now I have over 100 cases at any one point in time that I'm working on. So, and I have a law office with I've had a number of lawyers, maybe up to 6, 7 lawyers. It's come down a little bit since. So why don't we start next? Okay, when I think about race, and these are legitimate questions that as I say, where is race, and is it actual, is it implicit? Where along the way can you really see it? Now, for me, clearly in the police questions, I'm always looking at pretextual stops. What was the basis for that stop? Many cases, and maybe even smaller towns now, but certainly in larger towns, we've often had cases where the police would just stop that person just to figure out who that person was, and then they come up with some basis for the stop. Frequently, it could be a lawful basis, such as a tail light's out, brake light's not working, or didn't like the way you were driving. I had a case very, very recently that I just settled, and this was a young man, 35, 40-year-old man who was riding his bicycle, and the police just wanted to see him, what is he doing, where he was. He stopped him on a bicycle, and ultimately they got into an altercation, and the man was killed. But this was a pretextual stop, and but for that, this man would be alive. But
Mr. Burris, can I ask a question? Can you please define what pretextual means, just for people that may not know what that is?
Yeah, pretextual essentially means that there's no real basis for the stop, and you formulate some basis, some reason, and you try to fashion it in some lawful basis. For example, you see a person with a driver's light driving down the street, and you don't see the tail light, it doesn't come on when you think, or the brake light doesn't come on, or a kid's driving on a bicycle and the red light on the car doesn't come on. And it may be lawful, but the person really wasn't doing anything that would justify that kind of police action. And so I'm always looking for those kinds of cases. And I will tell you, these pretextual stops can turn into very, very bad situations, because we've had cases where people were stopped, harassed, ultimately an altercation takes place, and that person winds up dead. And those are the kind of cases that we see with some degree of regularity. I had detentions or other things where you're theoretically supposed to have a reasonable basis, reasonable suspicions for stopping someone. We see this often with people walking down the street, seemingly innocuously minding their own business, and the police will stop them because they think that they may have heard that a crime had taken place in another part of the town, and then they will say these individuals meet the description, when frequently they do not. Maybe two people, it's only one person. Maybe it was a red sweater, now you got a no sweater. The guy working with two hats on one hat, and the people here had no hat and no beard, but they get stopped because of the initial component that it was a detention based upon some factual information they had before, even though those facts do not tie into the person that you have. That is, we have detentions, and so you have to look to see what that's about. And we've had those kind of cases frequently, particularly in race cases, where people are stopped, detained, questioned, and if they give any kind of concern, they will wind up getting what they call 148s, 243s. The types of cases that drive me totally insane for a long time are these pretextual stops or these unlawful detentions that turn into contempt of cop, if you will, and the officer does not like the person's attitude, and they wind up charging them with an resisting arrest or an assault on a police officer. And I'm always looking for cases when a person brings me one of these cases and they've been beat up, and I want to find out, is there another underlying offense that's here? Is there a robbery, anything of that nature? And that will cause me to determine whether or not this is strictly an illegal detention, whether it's race-based or whatever the fact may be. But when you have different racial people involved, those are issues that you kind of look for. Obviously, car searches without consent, black guys driving a car, black women driving the car, they stop them for some minor traffic events, and then they want to search the car. And the person says, no, you can't search the car. Well, they search the car anyway. And I've had cases where even political people or professional people, whether it's lawyers and teachers, et cetera, who will say, no, you can't search the car. They then take them, they handcuff them, put them on the ground, and then search the car anyway. So it's not an uncommon phenomenon, but it's certainly the kind of cases that I look at very closely at the very beginning. Often they are race-based in some way, but because I also know that the real issue here is searching that car. And you know that during the war on drugs, this was a huge, huge issue. And one of the major concerns that I had on this issue, where they were stopping cars of black people, particularly if they smell marijuana. And we all know what the deal was, that the African American people were being charged with marijuana offenses, where the white kids who were smoking it, other people were not. And so these are issues that I'm looking at in terms of racial components, or just illegal interaction, because they become the basis for a civil case that I'm going to do or want to do. Investigations are a different matter. How cases are investigated, that requires you to take a closer look at cases. But we look at every case to determine, is it, something that may be race-based or not. I don't view every case as race-based, but I do know that there are indications that they are there, and you want to at least isolate it to the point where it becomes significant or not. My feeling is if you can do a 1983 case without race, you have a better chance of prevailing than you do otherwise. Bail settings, I don't think it's any secret. I did criminal defense work for a long time. And one of the things that drove me away from criminal defense work was the disparity in the whole judicial system, whether it was policing work, the bail setting, the trial of the case, jury selection, you name it. There's systematic racism that is fundamental to a lot of this. And I know people don't want to hear that, but having been there, seen it, I understand it. And all you got to do is think about the disparity in sentences that take place. And I don't believe that people necessarily think that they're racially biased, the judges or anything. But when you take the numbers in a global way, you got to wonder about it. But these are things that I look at, and I think that as lawyers, you should know that there are racial issues that are inherent in these issues, like it or not. Next slide, please.
And thank you for that that great description. Just looking at the cases that have come to the forefront, Elijah McClain, even before then, we know George Floyd, Breonna Taylor, all these pretextual stops and all these investigations. So
look, the case in Atlanta, that was the kind of case that one officer was trying to keep the thing quiet, work it out with the young man. Another
You're
officer,
talking about Rayshard Brooks?
Yeah, and another officer comes in, he becomes a hard person. And we see that often, because the biggest weapon that an officer has in de-escalating a situation is their verbal command. How do you talk to people? Now, one of the issues that I spent a great deal of my time, certainly over the last 25 years or so, gathering data and being at the heart of some of my work, is racial profiling. Now, racial profiling is one that is pretty easily defined. You substitute reasonable suspicion for race, and you use that and you draw around different kind of components of it. But I'll tell you, back in before 9/11, and at the time that Bush and versus Gore were running for president, there was a lot of discussion about racial profiling and dealing with those issues. And I was part of that discussion, and I had accumulated data from around the country. And I, Interstate 95, if you're from the East Coast, you know what that means, from Florida all the way up to New York Pass. Well, there's a lot of work that was being done around that. And then I was accumulating data here on the West Coast. But racial profiling is to me, is one of these insidious things that exists that appears to be minor on its face, but it has the impact of really impacting a person's sense of citizenship, because you get stopped and you want to question it and you have no authority. And me as a dad, as a Black man and grandfather, I talk to boys all the time about being mindful of racial profiling. And then when they get stopped, don't try to win, watch yourself, because if you put your hands in the wrong place, and you definitely will get shot and or killed. And the only thing that's helped in the modern day America to make that easier is the whole questions around the video cameras. And I'll talk about that a little bit later. Next. So these are common kind of vernacular terms that have worked out over generations, over the last, certainly my last 25 years. And that is, walking while Black, driving while Black, being Black in the wrong place and the wrong time, riding a bicycle while Black. I just was involved in a case yesterday where we have a guy dancing in the street while Black. People didn't like his attitude. They didn't like the fact he was dancing.
That was the Alameda person, the gentleman in Alameda.
Yeah, with him all day yesterday, trying to work through this. Clearly wrong. But I'll tell you, each one of these types of things have the potential to create a very, very dangerous situation. And I've seen minor events. I've already talked to you a little bit about the bicycle, but I had a brown person, an Indian man who's in the wrong neighborhood out in Danville, of all places. A person saw him, wanted to know, he's trying to find a location. They saying, what the hell is he doing here? They call the police. The police kind of run him down, check him out. He wants to leave. He hadn't done anything. That man was shot and killed. And before he even had a chance to, and the officer ran up on the side of the car and killed him. Many of you from the Bay Area, you know I'm involved in a couple of cases right now where officers have run up on the side of cars and shot into those cars and killed individuals who were unarmed. And so, but I'll just tell you, these are concepts that in the Black community, people are aware of them. I say that all you substitute brown and you get the same analysis here. But these are things that when you look in to see if there's race involved, you want to look to see what was the person doing.
And Mr. Burris, to add about Danville, my mother and I went to go pick up an item that we purchased from Craigslist. And so we were there early and we parked in the neighborhood, just waiting for the homeowner to show up who we were purchasing the item from. And we weren't parked in anyone's driveway, just parked on the street in the neighborhood. And a gentleman who was Caucasian comes outside, sees us there, 2 Black women waiting, and he just starts taking pictures. And so I didn't even think anything of it. My mom was like, this is weird. Someone's photographing us. And I said, well, I'm cute sometimes. So maybe he's a fan. I don't know. But he really wasn't. And so the other issue is like, okay, there are community members who, if who see you in a place. So it's not just the police that can bother you or harass you or bother you. It's actually people that live in these neighborhoods, right? So it's the consciousness of being perceived as a Black person in the United States and having to deal with everything that comes with. And it can be very dangerous and scary.
Absolutely. And, I counsel young men and women about these issues all the time. And it's really about safety. Just trying to get safe, and it doesn't matter how old you are. I had a 80+ professor, Black stately man, and he'd been a professor his whole life. He gets stopped, and police young officers didn't like the way he responded. Next thing you know, he pulled this old man out of the car, handcuffed him, and the guy cried, and he couldn't believe he could be treated that way. But it's that kind of humiliation that we do spend a lot of time working on. Some of the cases I'm involved in is getting officers to appreciate it's easy to humiliate someone. And you do that with the authority you have, you undermine their sense of space, you undermine their sense of citizenship, which I think is a huge, huge deal. I wrote a book, tried to write a book some years ago, and it was titled When Grown Men Cry. And it was about my experience with very proud working class Black guys who get stopped by the police for some minor event, get roughed up in front of their children. And when they try to tell the story to me, they would cry. And it was painful to me to hear that, because I knew that these men were they were working class guys, they got families, this guy had his girls in the car, his little girls in the car, and it was hurtful to him to be humiliated that way. And I understand that, and I see that, but that's what that humiliation comes from in officers who are young officers on top of that, trying to beat down and humiliate young African Americans or even old African Americans. But so these are concepts that we deal with that I understand and have a place for them. I'm not judgmental and think that there's one of these lurking behind every corner. I don't, because I have to maintain balance. But I'm mindful of them, and where it fits, then I will work with it. One of the efforts that I made a lot of effort here is I talked about on the 148s, 243s. That generally would flow from something like this because they don't like the attitudes of the person. is to get the DA not to prosecute 148s and 243s if there's no other underlying offense, because generally that's a cop-generated offense when those happen, because the person was just in the wrong place, wrong time, had something to say, talk back, and next thing you know, that person is charged with 148s, because once the officer puts his hands on you, he's taking you to jail. Next. Now, this is a little bit out of order, but here's the thing. When I was really working on racial profiling, as I said, I was accumulating data around the country, and one of the places that struck me was a New York Times report that a study that came out of North Carolina. Now, the reason why I'm sensitive to North Carolina is, as I think some of you know, my wife was a law professor in North Carolina, in Durham, and so I went often to Durham in North Carolina, and so I became a little more knowledgeable about some of the issues there, and I had some friends whose kids went to A&T. But if you look at this here, you can see this matrix that Black drivers were 5 times, 2 or 3 times greater than being stopped than whites. They were searched more than twice as often. They're more likely to stop Black drivers for no discernible reason. This is a pretext. Are more likely to use force. And this is the part that's troubling. The force issue minor force can lead to big force. And so we're always looking at those cases. I have a lot of force cases. And then the one that really is irksome should be to everyone is that the disparity in the law enforcement of marijuana. And all you had to think about, as I did, when Colorado and Washington State legalized marijuana, and all the young white kids and men came out and celebrated. And the thing that was most discerning then, that all the Black kids were in jail. They were in jail for marijuana. And one of those things that really bothered me a lot is the disparity in the criminal justice system. And that's where the systemic law enforcement issue. Now, California is doing a whole lot better, because since they've relaxed marijuana, a lot of these charges that people had have been eliminated. So there's really this sense of evening that process up. It hasn't even up in some other areas, such as cocaine and others, but there's efforts being made on these areas. There's movement. The question of whether or not the George Floyd issue as a moment or a movement, whether the movement itself gets into this disparity in the criminal justice system and in some of these other issues that I've been dealing with. Next, please. So when you think about race, these are the issues the very stereotypic things that are for real. Obviously, when you say race, obviously that's a broad category, but skin color, skin tone, dark complected people are different than light complected. Clothes that you wear, baggy clothes and stuff like that is different. That will cause the police to be more suspicious of you. The neighborhood, I'm interested on clothes. I have a son who's, 35, maybe not 35 yet, but he's in his early 30s. Hell, I can't get him to pull his pants up. And he's a decent guy. He ain't trying to be no criminal or anything, but I told him you can be characterized that way when the police see you, unless the police has been acclimated to understand that everybody with the clothes, the pants on their butts are not criminals. And everybody that's dark skinned with a hat or dreads or stuff are not criminals. And so you have to work through, these are the kind of things that you have to be mindful of. And, the time of day, the type of cars. I had guys pull over in a car. I represented a young man, college student. This is a few years back. He tells me, and I was doing a Festival of the Lake case many years ago. He told me he had been pulled over 25 plus times. And each time he got out of the car, he got out, he assumed the position, put his hands up, put his hands out, he could be searched, and they searched his car without permission or not. That was a level of humiliation that he had to accept just as being a Black African-American and trying to keep himself from getting hurt. So those are things that and the number of people in the cars, the types of cars. And, I've had cases around these areas that really strike a chord, because that those are bases of stopping people when you don't have to. the attitude, if you flunk the attitude test, you dare and ask questions about who you are, where you're going, what the hell you stopped me for. Next thing you know, they will have you turn around, put your hands up, put your arms behind your back, handcuff you, or make you get on the ground. And so these are things that we look for in terms of racial issues. Now, the question is, how do you deal with those? They may cause you to, it cause you how you work through the case, but it's something you have to be mindful of, that these are events that will give you some clue that all policing is not straight up, that there's these kind of factors that come into play. Next. So one of the, the racial bias in jury selection is a huge issue here. And how do you deal with that? I've been trying cases for a long time. I was a DA, as you know, in both the state's attorney's office in Chicago, where I tried cases, and tried cases as a prosecutor in Alameda County, and then a criminal defense lawyer all over. And so I had to deal with this whole notion of how to deal with jurors. Now, when a younger me, I was a little more aggressive and probably not well liked by some. I can see, I always had the feeling that jurors, some, particularly white jurors, were kind of put off from me a little bit, a lot, some were. But here's what I want you to think about, that jurors' perception of jurors in terms of guilt or innocence in criminal case, and I've stretched this on the police cases as well, because the essence of it is that jurors want to believe the police acted properly. That's first. And just like in criminal defense work, the presumption, although unstated, is that the black defendant is guilty of what's taken place. So if you think about it, and these are studies that came about, not my studies, but Kim Taylor Thompson, I know of her. She actually was out here, but she's a scholar type, and these are her studies, and some of them a little bit dated. But certainly as a foundational point, one should be mindful of it. You know that, and I know these factors to be true, that minority defendants are viewed in certain ways, like minority defendants are less believed and more thought about to be guilty of charges, can assist in, and so the issues of having minorities on the jury, and this is a big deal, because if you have minorities in the jury, you have more of a chance to have a real discussion about it. I tried a case, and I'll tell you, federal case a number of years ago. A guy got beat up badly by the sheriff officers of Alameda County. He was in custody, so he had been to prison and all, so he had a record of some kind. But this time he was complaining about the food. He was complaining that he wasn't getting food that he was entitled to get. And so they took him outside and they beat him up and bloodied him all up and then brought him back in. And so I'm doing the case. Ultimately, I got a defense verdict in that case, and a juror wrote me 2 weeks later and said to me that, Mr. Burris, that jury didn't care about your client. To him, he was guilty, and they even believed that he had created the blood spool himself, that he had made himself bleed. And it was shocking to me, but it was what one has to deal with in the perception of individuals. Now, I know
Mr. Burris, can I ask a quick question about that? When we're talking about racial bias and people's perception, where do you think this racial bias and these negative perceptions that are associated with people that are Black or African American or even part of the Latinx community, where do these perceptions come from?
Well, they're historical, obviously. They're deep-seated. These are deep-seated.
So do you think that they are a continuation of ideas developed through slavery to try to
the building
oppress groups?
I do think it goes back to not only back to the perceptions and the relationship of Blacks and slavery and Blacks in the North too. One should not forget what was going on in the North during slavery, because North was in fact benefiting from the slavery. And so the mistreatment of people that was accepted by everyone, and all the notions of people. And if you go back to Thomas Jefferson and and all the political leaders of those days, they all had perceptions, and even Lincoln, that blacks were inferior. But then as we move through the Reconstruction, one of the things you got to keep in mind is when media became a big deal, when motion pictures became a big deal, and all of the memorabilia at the time that was being created was depicting African Americans in the most negative light. And those traditions carried on in terms of relationships because people had less jobs. They had to do the minor trivial positions. And I think the cultural view of all this developed over a period of time. And it's deep-seated, and you have to work hard to get through it. As a trial lawyer, as a lawyer, I'm thinking this, I have to evaluate jurors. I know that some jurors are biased, and the question is, can I identify who they are, so that I can move them off the stage through preemptive challenges or for a cause. But I start from this premises here, that jurors, African-American jurors, have to work hard in these places, and that white jurors are more likely. Now, I do believe that there's a changing, as I've seen, in jurors over the since Rodney King. And I say that because Rodney King was such an eye-opener to the world itself. When I tried the Rodney King case, I was vilified by the general population, just like we have all these Zoom and people making hilarious statements, Well, they made those statements, and I'm representing a guy who was beaten up it had to be his fault.
And we all saw the video. I mean, it was.
Yeah, we saw the video.
Inhumane. It was barbaric.
I know. We saw the video, and I'm in the middle of it, but I had people who were calling and saying bad things, that he got what he deserved. And how could you be doing this against these wonderful police officers? So that was then. Now I believe, over a period of time, since I've been involved in this process, of course, that we are seeing changes. And I do think we are having broader juror variety. Now, that's not everywhere. Certainly, the jurors are a product of the county in which you're in, or a product of just like, and this is interesting analysis, just like the post office now is working in a way to skewer the ballot box. Well, I'm going to tell you, for years and years and years, the jury commissioners in towns did exactly that. They worked to make sure that African Americans did not make it to the jury pool. And if they did make it, they would get kicked out for reasons that I'll talk about a little bit later. But those are issues so the attitude is deep-seated, and it goes many generations, and whether you get a handle on it, I think this progress is being made. I do think. Next, I'm sorry. I wanted to. So here's an interesting part about the juries that I think that it's important to keep in mind. If you have people of different ethnic on the juries, the data suggests they would deliberate longer. They even talk about the evidence more so. Make sure that they won't be inaccurate. You've all seen 12 Angry Jurors, that kind of play that went on many years ago. And I think that you will get a better group discussion. Now, the problem with it, of course, is that there's much efforts made through the system that has taken place, that's built in. You can pass to the next one. Next. Okay, so a lot of effort has been made, to kind of think through about how to deal with some of these police issues and how to select people from different areas. Now, I'm involved primarily in the federal judicial system, and in the Northern District, which is from King County up to the Oregon border and over to Vallejo and Contra Costa. But I'm also involved in the Eastern District, which also goes all the way up to the border, but go to the eastern border in Northeast. And so there are different people in all these neighborhoods. And so all these folks have different attitudes about the police, and I have found this to be true, that, 63% of people think the police tactics are fine. Now, people live in the suburbs, they think that they have positive views. They don't have negative views. And the live in the cities are different. And I'll say this, some of my good friends, lawyers, colleagues, they all have boys. When my boys were growing up, they never thought about any problem having an issue with the police. It never even crossed their mind. Some of them have grown men, so they've never had to discuss any issues about the police. Well, there's no African American boy that I could think of that you don't have this concern about the use of force, whether it's deadly force, etc. So there's attitudes that we have because of what the police have done. And when you look at the data, we'd all talk about, at least for the last several years, 1,000 shootings have taken place by police and killings. Now, we don't have any that, but none of this was accumulated by the government. It was all accumulated by the Washington Post or the Guardian. And they clearly illustrated that blacks are being killed at a disproportionate rate, unarmed blacks at a disproportionate higher rate per capita than other ethnic groups. It also shows that mentally impaired people are, in fact, are killed at a very high rate. And so,
Mr. Burris, just to add, Professor Kimberly Crenshaw, who is the founder of critical race theory, and she's a professor at UCLA, I just saw her Instagram post the past 2 days, and she has posted a lot of instances of Black women who were stopped and killed by the police, who were having mental health breakdowns, who had prior instances with the police where they either were bipolar or where police knew that they had some mental issues going on and they were still killed. And so the mental health component of it is very big and impactful, especially for communities of color.
It's huge, huge, huge. And it's an area that we are doing a lot of work in. I've done some writing about this issue, how the mentally impaired are policed. And, part of it is that they treat these like felony cases. And, we have mentally impaired people who are killed often at a much higher rate than they should be. They should not be. And I've had well over 10, 15 cases. I got at least 5 pending right now. Some of you from the area here, that the Miles Hall case out in Contra Costa County, where the young African-American man was shot and killed, who was having a nervous breakdown, a mental breakdown. The police knew it, but instead of de-escalated, they went and killed the kid. But this is why we have African-Americans think the police should quickly use deadly force, because the data suggests that they do. There's other data out there that shows, and I'm not a scientist or sociologist, but they have some data that shows when they've tested white and blacks, white officers, when they're looking at a potential black person versus a white person, how fast they draw their weapon. Well, the data suggested that if a white person is looking at a black person, they were quicker to draw and shoot their weapon than if it was a white person, which means they would wait a little bit longer to see what that person did. And that's what we get out of that, and that's why we have these high numbers. Next. So once you get through all of that, I'll get back to some other stuff here. But when you're dealing with race questions and you want to prepare for the voir dire, there's 2 ways of doing all this. I mean, you got 2 courthouses. You have a state courthouse, which allows you to ask questions, within limits, and pretty probing questions. And then you have a federal judiciary that doesn't allow you to ask any questions. They give you 15 minutes to ask the questions. Now, the difference is that in the federal system, the judge would allow you either to do a questionnaire or they will allow you to prepare a list of questions that the judge himself, him or herself, will then read and then may or may not follow up. But you have to be prepared to figure out what it is you're trying to get done. In race questions, that's easy because that's a question of how do you want to have the discussion. The areas in race cases, the big areas are race and 2, police interaction and attitude toward them. Those are the big, big issues. And so what we normally have, we recognize, first of all, when you're doing a federal case, you got to have a pretty good strategy because the voir dire goes real quick. The judge gives you 10 or 15 minutes. But before you get to that, you would have given the judge as many of the questions you want him to answer, the subject matters, and you've done a questionnaire. We normally like questionnaires because it allows us to ask more specific cases or questions, and those questionnaires allow the people to be more specific, and allows us to review what they've had to say before we have to answer any questions, and you can literally squeeze some of them out. You can during that period of time. So what you're trying to do is get people who don't have overt racial bias against your client or against you, me, and try to neutralize those negativism. You're not going to be able to do it for all of them, but then you'll have people you're trying to also eliminate, and those are really the pro-police people, and that's really people who have a lot in their families, and so you have to work hard to identify those individuals, but part of it is you have to be observant, and then if you do ask questions, then you're looking to see what the other side, what questions the defense is asking, what questions you're asking, how the people respond. It is more of an art than anything else. Next. So I talked a little bit about this here. The jury questionnaire I have found in high volatile police cases, which most of mine are, is that the questionnaire is a very important thing to do. And you got to convince the judge to do it, but judges who understand civil rights cases and modern day America will generally allow that to happen because people have real biases and they feel very, very strongly about it. And those who are against the police, they will say it. Those who are for the police, they will say it. And they will say it in very strong terms. So the object is to figure out who those people are and to try to get them out for cause or ultimately you may have to use a preemptive. But a preemptive means that you have a right under the federal or the state system to exercise your charge to kick someone off the jury for no reason with some limitations. And I'll get to that next. Let me see if that come up next. Well, no, this is the questionnaire. This is the kind of questionnaire that allows you to ask questions in privacy. For example, what do you think about police or law enforcement officers in general? General question. Do you think the police misconduct is a problem in your community? Why and why not? And these are big issues. And then you want to talk about Black Lives Matter. You might have a question and response like the president had. Or you might have some people that says, no, it's an important one. But you are probing. You may want to know what TV programs you watch. Do you watch Radio Matters or do you watch Fox TV? Or some other programs, cop programs that show cops in different ways. These are the kind of things that you have to do that are equally important as the race question. Race question really is, who do you associate with? Do you have any people in your neighborhood? My big issue is, who do you get to supervise? Are you a supervisor? Are you a decision maker? Do you get to decide who gets to stay or who doesn't get to stay? Have you ever decided that against a Black person? Have you ever a Black person decided against you? Not that you get the answers that you want, but you're getting a sense of what that person's thinking is. And that's extraordinarily important. Next. So here you're talking about the judge. And I know I spent a lot of time on jury selection because this is where race matters. And here, voir dire is very, very important here. And this goes to the kind of questions you want to ask. And now, you may have issues that are high visibility. High publicity. For example, the other day in one of my cases, the city decided they're going to file a gag order against me and make for a change of venue. Well, those are not, the change of venue is a very difficult thing to do. The gag order may not be as difficult depending on what has been said about the case. I can see where a judge wants to keep the lawyers from talking too much. I've certainly been in cases where the judge has shut down everybody. But that's the publicity in the case could be helpful or not, depending upon your perspective. I will tell you that I generally, do when I take a case, if a person has been negatively represented in the public, I would generally try to find out how I'm going to have a press conference to put that person in a more favorable light, because you don't know where the publicity is going, and you don't know where the social media is going to go. And you don't know how any of these people might ultimately wind up in your jury or talking about your case. So you have some responsibility to deal with that. Sensitive case issues are obviously there. Sexual cases are the most. I've certainly been involved in cases where sexual issues have to be work through, or a person's domestic situation. You just have to work through that. So you're trying to figure out these kind of things and talking to the police. So one of the big issues is that there are issues where people feel it's unfair to second guess police, unfair to sue the police. Other people think that blacks are getting an advantage. Other people think damages are outrageous, as everyone knows about the McDonald's case. And so you got to work through those. And then do you think that black people are entitled to more damages than not, or white people are entitled? Can you make a decision without regard to the racial issues? These are issues that you have to confront when you're dealing in a race-based case. Next question, next point, next. Certainly doing voir dire, this is an easy one, and I only say this to remember that it's easy not to listen, and it's easy not to observe the group dynamic that's taking place. Because people say things, you may not catch it, or they may are saying more, but they're talking less. You got to know groups. People go on breaks, and before you know it, they formed a little cabal or a group. You got to then decide whether you want that group to maintain itself, or do you want to break up that group because you don't like the person in the middle because of something he or she has said earlier in a questionnaire or somewhere else. So in many ways, you have to be very mindful when you're doing voir dire, because at the end of the day, these people make decisions on your case. No matter how good the case is, they can make a wrong decision for you, and you could have missed someone. Just like in the case I had where the guys didn't care what my guy had to say, what happened to him. They'd already made up their minds. And there was only one lady who was upset about it, but she wasn't strong enough to fight them off. But that does happen. Next. Now, here's an issue that's important. We talk a lot about racial bias and jury selection. Well, in the federal system, we have what they call a Batson motion, and in the state system, you have a Wheeler motion, which basically means you cannot use race as a basis to select, deselect someone from the jury, even though you have preemptive challenges, and you have a right to use those preemptive challenges any way you want, except you cannot use them for race. And that happens when, for example, there are 5 blacks in a jury pool of 300 or whatever that number is, and they all get up into the jury panel and you kick them all off. And you listen to what they have to say, and it doesn't matter what they have to say, you kick them off. That's going to cause a Batson motion. A Batson motion means that you got to then go to the judge, explain to the judge why it is that you kick those person off, and you better have a reason and a rationale that is consistent with not consistent with race. And this does happen in the same way in the state system. There are many cases, I've had cases where I've seen that I've filed the Batson motion, but I have decided not to go forward, because if the judge grants the Batson motion, the judge will start the case all over again and pick another jury. And so sometimes you have to decide whether the devil you know is better than the one you don't know. But it does mean that you do put the other side on notice. And these are situations typical when you have black defendants, black plaintiffs, and white police officers, and white lawyers, and you have black lawyers. You can see all these matters coming forward. They don't have to be, but part of the observation as a lawyer is being ever mindful of these kind of considerations, because the jury panel that you see is the one that you're going to have no matter what you might think of your case and where you think that might happen. That's that jury panel. And this goes to the whole question of the implicit bias that exists in certain counties. And because they decide, the jury commissioner decides who gets called. And they will give people, if they want to give the people in West Richmond excuses, they let them have excuses. If they want to give the people in West Oakland excuses, they don't make them come in. Or in the federal system, you have certain people that don't have to come in if they can't do this, that, and the other. And so traditionally, you had these jurors who were composed of all senior citizens or people who didn't have jobs. Well, that has changed considerably since I've been practicing, and it's for a good thing. It's not perfect, but you have a better chance. Certainly now, I've done three federal trials in the last several years, and each one of them had minorities on the jury panels, and they participated in the process. And then I've had cases where I've had no African Americans on the jury, and the jury was a good jury too. So it's still a question of, it's not just race. It is a question of examination, and to some extent, it's the luck of the draw as well. But these are two motions that are available. One's in federal court and one's in state court that you get to file in the event that that you have a sense that the other side is exercising their challenges based upon race. Now, keep in mind, this works both ways. You can't knock off, if you're the plaintiff lawyer, you can't knock off all the white men, because the judge will say, well, they'll say that's violation too. And when I did the Rodney King case, that happened to me. I was knocking off white men who I thought were not going to be good for us, given the nature of this case. And they filed a Batson motion on me, and I had to go to the court and explain why I kicked them off, which was an eye-opener for me, but I did. And most times lawyers do have reasons. The biggest reasons, of course, is that people have relationships and attitudes toward the police, or they have attitudes toward race. Those are the big issues. And sometimes they have attitudes about money too. They don't want to give up damages, but that's all part of, that's not a basis to get the person knocked off. Money, damages, but race, sexual orientation, anything that goes to what they call public policy, the protected class of people, and race and sex and gender orientation, those are all part of it, okay? And race is not just black, obviously, it's all ethnic groups. Next. This is a term that is very challenging to us all as we work through the judicial system, and that's the implicit bias. Everyone talks about implicit bias these days. They talk about it in ways that says that everybody has some form of implicit bias, and that may be true. And I'm sure it is. People have attitudes. And the question is whether or not those biases that they may be, maybe not even unaware of, but trigger a discussion point in them, or it causes them to influence their decision. We often feel that way in terms of with police. We have police that are inherently biased, we think. At least we make that decision. I don't know that that's necessarily true, but we are concerned about it. And the reason why we look at it, because it may not be one-on-one, but look at the totality of the numbers. And that's where you start looking to say, well, maybe there's something else going on here, because all these numbers can't reflect that the non-racial reasons for it. And that's why you look at the structural racism, you look at the data. And what does the data show you? Because then you can start drawing some inference. If it's not race, then what is it? But the data then becomes important, and particularly if you look at the disparities in the things that take place, whether it's in arrest and sentencing, who gets what, how long they stay. These are very significant points for implicit bias. But it is an evolving concept. It's an evolving one, just like most things are these days, that we don't know where it ultimately is going to go. We ultimately hope it works to a more perfect, quote, union, as they say, and that people will be judged less by these implicit biases and more about the objective facts that have occurred with them. Next. Now, we've gone through all of that, but let me just tell you what the kind of the civil rights claims are that are available. Now, it's 42 USC section 1983 and 95 is 85 as well. These are this is the enabling statute of the various Bill of Rights. That's all that is. It's the enabling statute. And so you can bring forth all your cases. The only one you all should know these: speech, assembly, and detention, arrest, force, providing medical care. I haven't mentioned this. Adequate Medicare, intervention. These are things that are taking place. Monell liability is something you may not have heard of. And Monell liability, although I may have misspelled it here, I think it's one L, although I keep going back and forth on it. And the Monell liability is one of pattern and practice that says that a department can be held responsible if they engage in a course of discriminatory law enforcement with a pattern and practice. Now, that could be the use of deadly force, where there's a ratification. It could be a failure to discipline, where there's a whole pattern where no matter what an officer does, the officer is never disciplined. We certainly have that feeling about a couple of cases we're involved in. This is how you bring about change within a department through the pattern and practice. You can bring about the change of whether the chokehold should be used, whether taser should be used, whether training is inadequate as it relates to the use of deadly force, whether or not the supervision is inadequate. You can all do this under the Monell liability. Now, the thing to keep in mind, when you're in a 1983 case, it's an individual liability for the officer per se, not the municipality. So you sue the individual. If you want to sue the municipality, then you have to do it under the Monell theory, and you have to say there's a pattern and practice of some kind that exists. And that's an important distinction that you should keep in mind. That so that you know, and I tell everyone, lawyers, young lawyers, new lawyers in particular, do not go down the Monell liability road unless you have sufficient pre-existing knowledge of a pattern and practice. It's a very, very expensive proposition. The courts don't like it, and it will just get you a lot of law and motion work and very little result. So I would say before any of you want to do that, you talk to somebody about what you have so they can let you know if they think that is the kind of thing that you can get by on a Monell, get state liability. It's a very significant cause of action. Obviously, the 14th Amendment, equal protection and due process clause. This part is important because I haven't gone through the death cases, but where this is important is that under 1983, a death case where a person has been killed, that person has Fourth Amendment rights who was killed. And the damages are maybe survival, whatever, how long it took him to die. But he has civil rights, Fourth Amendment, then he has the survival. The parents have what they call a 14th Amendment, and or the wife or spouse. And those rights are more about the loss of the relationship, the loss of the familial relationship. That's a 14th Amendment claim. And so you have to know that, and it's changing in terms of what the standard is, whether or not it's deliberate indifference, was it one to shock the conscience, high standards, but all can be done given the fact pattern that you're involved in. So we file routinely 14th Amendment claims, and depending on what these are just a small version of the various types of claims you can have. We do have them in jail cases, county jail cases. We have lots of cases against the county jail. And believe it or not, some of those are for suicide, where they failed, or two things, suicide and failed to provide medical treatment. And so those are huge issues. Aside from the beating, we have force cases in county jails, but we have a lot of different things that we can have in county jails, and asphyxiation cases are pretty common. We've had a wide range of all these cases in 1983. I can't even begin to talk about them. I've represented so many people, I can't keep track of. 1981, as I put up here, we haven't really successfully done a 1981 cause of action case. I certainly have wanted to do one and gave some thought last year. That's probably why I have this up here. That's a race case. And if you're in law school, you remember 1981, and there's this particular, but I don't worry too much about it because under 1983, you don't need race. You just don't need race. Race is a cherry on the whole thing, but you don't need race. And that might get you the punitive damages if you need. But this is sort of the framework for the 1983 cause of action. There are many more causes of action you can have there. Anything where a person loses a right that they had that was caused by the institution, that can be a 1983 cause of action. All right, next. Now, obviously, there's a state part of this as well. Now, I didn't tell you on the federal cause of action, there's a 2-year statute of limitations. But under the state cause of action, these are comparable causes of action, which we typically do and filed in both cases. But you have assault and battery, of course. You have wrongful deaths, of course. You have false imprisonment. I have it there. False arrest, false imprisonment. These are all, they mirror the federal cause of actions. There's a Supreme Court violation called the Bain Act that kind of mirrors it, but there's a lot of discussion about what are the standards under the Bain Act. That's an evolving case. The U.S. Supreme Court just made a decision. Not the California Supreme Court just made a decision about the other day. But some of the things you should know going forward, if you're doing state cause of action, which may be more appropriate now, is an AB 392 was just passed last year. It changed the standard for using deadly force. And it raises a real question about the standard is objectively reasonable, which is 1983 statute. But here they, under deadly force, it can be reasonable, it should be reasonable. But then the question is, was it necessary? Was it necessary? Which is a real distinction. And more importantly, the question of one's tactics can also be called into question here. That is to say, a split-second decision means that you shot because you felt you had a shot, you had to shoot. But that's not the end of the question. That is a portion of the question. But the real question is, what did you do to put yourself in that position? What did you do? Because if you did something to put yourself in a position where you had to shoot yourself out of it, that's not acceptable under this particular statute. And we've been fighting that particular battle for a long time. It's one of my reframes. You can't create dangerous situation for yourself and then shoot your way out of it and think that you're protected. We have that often in these shooting in the cars cases where officers will jump in front of a car and shoot into the car. When they didn't have to jump in front of the car, they could have moved to the side. So that's an important one. The other thing is AB 748. AB 748 is disclosure of police videos. This is one of the most significant revolutionary acts that have taken place in policing since I've been doing police since the 1980s. And the reason why is that Rodney King was the first time we saw a video of the beating. Well, since then, we've had cell phones and we've had car videos, and we've also had body-worn cameras. The law now is that if the police have body-worn cameras, if they have car cam video, they have to disclose those within 45 days. This is a very, very important concept because it has changed the whole accountability question for police officers. In fact, I was just reviewing a report today, and it was in the news today where these officers in a killing of a homeless man, although it turned out to be my case, homeless man, that they all gave statements indicating the homeless man did certain things, i.e. stood up, pointed at them, and pointed a gun at them, made eye contact. Well, the video that were taken of it did not show any of that. So we've had many cases more recently where the video camera gives us a real better clue. It's a bird's eye contemporaneous view of what has taken place. And so if you're gonna, so therefore state cases in certain counties are great. Certain counties are not great, depending upon your practice. And if you're a local lawyer in a particular county, then for Modesto or Stanislaus County or something like your local lawyer, then you could bring a case like this. If you're an outside person like me, you wouldn't bring a case like that because I would be an outsider. But I would always do federal court because I know the federal system, and I've been up and down the federal courts throughout the state. But those are
First, we have a question from someone. Does, in terms of AB 748, does that mean full unedited videos must be disclosed to the public within the 45 days?
It has not been unedited. I should say it has. I haven't seen them where we've had it where they've been unedited.
Okay.
I think you have to look at that video because what happens when we get videos, they are talking about the video. They're editorializing the video. So they're giving a story with it. But I think that we have to, this is an evolving issue here. It has not been fully vetted because just like this question come up, other questions are coming up about it. And just like on the deadly force, there's another one I want to talk about. Let's go to the next slide. I talked a little bit about this already. This 148, 243, and 1983 claims. This is just how do you do a case. You know, I think you got to know how to investigate a case and get the case in the right frame of mind in order to get it done. Because there are videos, if you don't have videos in the world these days, it's a much more difficult case. Cell phone videos, I mean, obviously, the Oscar Grant case was the first major case that came about with cell phones. And I think that now everybody is a potential witness They all carry cell phones. I tell everyone, you see something, do something. Now, the problem on it is the police will try to take those cameras and will destroy those cameras. And so to the extent, before you turn a camera over to the police, you better put it on lockdown, or you better put it somewhere saved, sent somewhere, so it won't get destroyed, because the cops, will do it. And that's one thing they will do. But these are the things you got to do in order to put together any kind of viable case. Next. Of course, every case that I'm involved in, you generally got to have some consultants or expert witness, forensic experts, because they have to be able to tell the story, and there are a lot of different ways that it has to be done. A toxicologist, firearm examiner, ballistic, medical, tasers experts, video. We always have a video and acoustic person to enhance our videos, and they have made huge differences. That you can look at that video and slow it down, you can see things that allows you to make better judgments about it. And so that's been important. Obviously, police practice experts in police cases, and the more serious ones, every case doesn't need one, but certainly in cases where you're looking to see whether or not the training was appropriate, or whether or not the policies themselves were followed. Was there something that says you can't use a weapon in a certain way? For example, a chokehold, or whether or not a taser can be used, whether certain types of weapons. You need a police practice expert to tell you, particularly in dog bite cases, which we have a lot of, to tell you the K9 shouldn't have been used, or the K9 should have been called off. These are things that you get to talk about, and you need an expert to help you through it. And so obviously, and then other areas, the internal affairs is a huge area, the background of the officers, military service, PTSD that officers may have. These are areas that you must know about if you're going to really do a case. Now, they don't all apply in every case, but they apply in a lot of them. So it's up to you to make a determination which of these applies in your particular case. Next.
Mr. Burris, we have a question back to the police recording. Someone says, does that mean if you record something, you should make a duplicate or post it to the internet first? ? The cops literally destroyed all the cameras they saw in the alleyway when they killed Andres Guardado in LA. Or should you contact an attorney ASAP?
Well, I think that you should save what you got first. Save it. So that when you do get to a lawyer, you can have it. You may ultimately have to turn it over, but you don't want to turn it over unless you have saved it, And if you're right there and the officer sees you doing it, you try to save it as quickly as you can. You don't have to give it over. You don't have to give it over. They have to, if they want it, they have to get evidence. They have to get a search warrant or something like that. But, I've had cases where the police have come and arrested the person for videotaping. The argument is this: you can't get within 10 feet of a police officer when they're involved in their business. You have to give them room. So when they say back up, you should back up. And one is for fear for the officer. You got to protect the officer for yourself, but you can't interfere. And but you can videotape, and you should be in a distance away. I've had many cases where a person videotapes an officer, and the officer didn't come beat him up and take the video, and I've had to sue him. So those things do happen. But the camera that you have is yours. But you should try to make sure you have a backup in the event that it does get taken by the police, because police are brutal or something. They would just take it. They'll physically take it. And then you have to have some basis for doing it. But I would always say that if you got a camera, you should talk on that telephone to somebody, telling them that you have just whatever you videotaped, and this officer's over here trying to take it, and that you have saved it as quickly as you can. Because if an officer destroys it, that's a spoilization of evidence, and it can be used against them. I'm certainly in a case right now where that issue has come up, where the evidence is being destroyed, has been destroyed. Now here we're just talking about getting documents. I mean, there are those who do this better than others, but you certainly should. You can get Freedom of Information Act. You can get documents. Obviously, you can't get documents that are right in the middle of investigation, but they can't hold them from you indefinitely. Now, if you're in lawsuits, of course you have great, and I haven't gone through any of that, but lawsuits, you have great discovery techniques. I'll go to the next one, I don't see any of that. And next. Okay. Yeah, here's some areas I want to get to right now. Okay, so police personnel files are extraordinarily important in any police case. Okay. In the state court, they have what they call pitches motions, which then allows you to get evidence based upon certain kinds of things. The state system does not give you freelance on these files. Evidence code 1043 and 1045 let you know how you can do it. Obviously, you have motions that you can have properly returned. SB 1421 means police records involving deadly force, perjury, and sexual assaults, no matter whether they're related to the case you're involved in at all, is discoverable. You may wake up and says, I remember when Officer such and such did something 5 years ago. Well, I want those records. You can get those. Now, under the federal rules, of course, discovery of police records is pretty easy. Those are not challenging issues. There are no real privacy acts in the federal system, with one or two exceptions. Of course, you have the issue of marital privileges, and you may have a religious one, but police, and you have certain privileges around medical records, but unless it becomes an issue. But those are all issues that you have to work through a protective order with the other side. But you can get these items, and the police records in and of themselves, you have to recognize that they're not, you can't get them and turn them over to your friends. You can't even turn them over to the client. You can let the client see them, but you are responsible for maintaining those records if a protective order is given, and you may have to, and you're supposed to turn them back when it's done. But you can get the records no matter what they tell you. You just have to be persistent, you know. And I can tell you, if they don't want to give you the records, all you got to do is threaten to do a meet and confer. You got to do a meet and confer, but a motion to prove up it. There's another term for it, I can't think of it right now, but the term, you can get the records, and you should not be shy in trying to do so, because you will need them. That doesn't mean they all come in evidence, because much of this is 404B stuff, which means if you've done state court, you know that some of it is like state court where you want to put stuff in from common plan or scheme. Well, the federal system is the same. You might be able to use it later for punitive damages of some kind, but it's always better to get the documents. Then it becomes more of a better negotiation tool if you're trying to settle a case. Next. Okay, this is an important concept here. Deciding whether and when to file a federal civil rights case. First, you got to know, do you have a pending criminal case? All right. And if you do, then you cannot go forward. I should say, you'll be stopped for the most part from going forward. And you don't want to go forward because your client will be subject to Fifth Amendment challenges that you don't want him to be giving testimony of statements out while there's a criminal case pending. But you do have to file a claim. Just keep this in mind. Whether your client is involved in a criminal case and you think there's a civil case that's related, you still have a duty to file a claim within 6 months. If you do not do so, you will not be able to file a state claim, a state cause of action. The federal system does not require that you have any type of administrative claims. You have 2 years to file the lawsuit. And sometimes you want to wait that period of time. Now, criminal cases will stay a civil case. So if the case, once you file a claim, then it can be stayed. Federal system, there's a question how long it can be stayed. I don't know the answer to that, whether it's probably stayed for the period of time in which the criminal case is pending. That makes more sense to me. So these other areas are important issues that you have to deal with. I talked about the statute of limitations and when does it start. Ultimately deciding, go to the next one, whether you file state court or state or federal court. This is a matter of preference. Most lawyers prefer to be in the state system because you don't need a unanimous verdict, and it helps deal with you in that sense, and particularly if you are a well-known lawyer in the county. The disadvantages, of course, is that the discovery rules are stricter, but you do have to pay jury fees. I find it not very orderly, and I don't find that the judge is generally very knowledgeable about civil rights cases. The federal court is a very orderly process, very liberal discovery, but you are on a strict timetable. The judges are very knowledgeable. The statute of limitations is 2 years, and so. But there are strict and orderly process. The case is assigned to a judge at the very outset, and that judge will control that case early. You have strict guidelines in terms of discovery requests. If you're going to do federal work, you need to get in and learn the federal rules from federal civil procedure from 26 on to like 37. That tells you all that you need to know. In the federal system, you'll be more subject to discovery motions. Go to the next one. Okay, this is just the basic law here. When you're dealing with excessive force cases, the leading cases, Graham versus Connors, and the standards objectively reasonable officer. That's why you need an expert, because the expert has to give you an opinion that opinion was not objectively reasonable for the office. And so that's an important concept that you must learn. I tell you that the state system now puts under the system of whether or not it was not only reasonable, but was it necessary? And so that hasn't worked its way through. That's a state's issue that has to be dealt with. I talked to you a little bit earlier about the Monell issues, and you can see this failure to train, ratifications, search warrant, all these areas. I've done work in all these particular areas that I know that's significant. What's next? Now, if you have a department that you think is really in bad way, and one of the things that can happen is that you can bring the federal government in under a statute called 14141. This happened under the Clinton administration. It allows for you to investigate cities for pattern and practice. They also have a component here under the Offices of Community Policing, which comes in and helps cities deal with some of the departments. I have been involved in a number of the community policing. It's a very good program, but unfortunately, when the Trump people came in, they kicked them all out, as they said that they're not interested in evaluating police officers' concept. But one day, this is something that you may never know where you are in a city that this becomes critical. And if you can't do it, you ask justice to do it. Next. So the one case that kind of illustrated all these areas is a case commonly referred to as the Riders case, which I was involved in 2000. I hate to say that. I hate that more than anything else, where I represented 119 people, Jim Shannon and I. And we were really representing an entire community that had been a campaign by 4 or 5 officers known as the Riders, who were engaged in, malicious negative conduct, ranging from false arrest, planting of evidence, perjury, assault and battery, etc. And we worked on this case, and we ultimately reached a settlement for the clients of, some dollars. But the more important question here was, we reached a negotiated settlement agreement referred to as the NSA. Now, this was a model achievement at the time in working through this. And this was something that Jim Shannon and I did ourselves, working with our own police practice experts. We developed what we consider to be 55 tasks. And those tasks were we thought to bring the department up to modern practice and bring the best practices. And part of that is my big issue at the time was racial profiling, and we wanted to gather the data to see whether or not Oakland really was stopping people unnecessarily so through stop data. Well, it turns out we couldn't get the data for almost 11 years because the OPD officers would not work together. They would not gather the data. They would not fill out the cards. And it wasn't until 2014 that we actually got some data that was able to be analyzed by Stanford professor Jennifer Eberhardt, who's a real specialist. Next, please.
And I believe Professor Eberhardt does a lot of implicit bias work as well. I've seen her name at various implicit bias MCLEs, so she's definitely someone we're checking out.
Yeah, she definitely is. Go to the next one. I'm sorry, you went back the wrong way. Next. Okay, so Professor Eberhardt worked with us very closely. She had a team of social scientists at Stanford. And this is what came out of all of this, which was really startling. Not that it wasn't known, but this was the data that supported it. And the officers stopped, searched, handcuffed, and arrested more African Americans than whites at a rate that was disproportionate to their status in the population. Here's some other aspects that was interesting. 60% of Oakland stops were of African Americans, who make 28% of the population. And there's other data that Oakland officers made at least one stop during the 13-month period of the study, making at least one, but only 20% stopped a white person, whereas 96% of the officers stopped an African-American person. And what we really saw is that the African Americans were really feeling the brunt of this effort on stopping police. And so it was our mission to get those numbers down. And it took 3 or 4 years. We can go to the next. I don't know if we got the next one, but 3 or 4 years before we started seeing real differences. One of the areas that really confounded me was on the handcuffing. And we found that 70% African Americans they were stopped 70% of the times more so than whites. But the equally important part of it, it didn't matter what they did. They were handcuffed. And this was offensive to me, because the whites who were similarly situated, who had done nothing as well, they were not handcuffed. And so this was a big issue that we immediately had them to work on to get some better sense of that. We had the same issues around people being stopped. And so we worked really hard on that. And we started to see those numbers come down. Next. So as we get toward the end here, let me just tell you that the Oakland Riders case is still going on. There was what we got going there was an independent monitor who was supposed to determine, evaluate, and see if the department's in compliance with the various provisions that we made in the agreement. We had 55 tasks that we had worked on, and we were trying, and many of those were significantly important because they went to the use of force, they went to the use of stop, they went to consistency of discipline, the ability to the Internal Affairs Department. And another one that was also dear to me was the whole question of disparity and discipline within the department itself, whether the African American men or women were being disciplined at a higher rate than other officers. And so these were areas that we were able to cause the department to take a real look at. And to their credit, they worked pretty gallantly in trying to get it done. They just haven't done it. I think that part of it is new cases would come up and there'd be setbacks. When we thought we were done several years ago, there was a big sex scandal. And now we're in another case where we have a shooting scandal. But efforts are being made, I think, to bring about it. Now, what we have learned that because of the work that was done, we have substantially fewer police shootings. You know, we have 1 in 3 or 4 years. Well, we used to have 6, 7, 8, 9 a year, 10. So, and the number of lawsuits have, we think, gone down. So it has been significant for us in working through it. And I think it's been significant in other cities as well. So as you look at this issue of policing, remember that there's broader issues involved in the individual cases there. There's a possibility that you can do something that can have far-reaching ramifications. That for us, you know, myself and Jim Channon, at least in the city of Oakland, despite all of these problems, we have fewer people being arrested, fewer people getting 148s, 243s, fewer people being talked to in a dastardly, nastily way. And of course, these are important variables that are conditions that I think it goes to the question of policing. And it's the very reason why I do police work, because I do want to see reform. And I'm thinking and hopeful that this issue now around George Floyd may bring about more changes in more departments, because other departments are thinking and talking more about it. But at the end of the day, it will never work unless there's a political will. That is the mayor, the city council, and the police command staff, including the chief. If they're on board, you can get it done, because then you can have transparency, you can have discipline. But if they're not on board, you can't. So anyway, those are my thoughts. Okay.
Well, thank you so much for the information. It was very helpful, very relevant, and very impactful. We have about 4 minutes left, and I've asked you questions throughout the presentation. But if anyone has any specific questions to ask Mr. Burris, please feel free to. We have one from Rob in the chat. He says it's slightly off topic. He says, change of venue in the Rodney criminal case was extremely controversial and heavily criticized after the verdict. Have California judges been more reluctant to grant change of venue requests as a result of that case?
I don't know about that case, but we had a change of venue up here with the Oscar Grant case. Mm-hmm. In that case, we had a change of venue because, number one, it was known widely throughout the county. Number two, the judge who did a preliminary hearing, he makes an opinion that he thought it was murder. And so it caused quite a stir. And so the judge ultimately decided that it would be better sent somewhere else. I don't think that change of venues are granted that easily. We had the Peterson case out of Fresno or Modesto. That was changed, brought up here. But I can't think of many others that have had a change of venue. Now, if you have a small county, you can have a change of venue if it's a notorious case. But if it's a case of large urban situation, I just don't see that. I don't see many cases have a change of venue out of LA County. That case was unusual. We tried the civil case in LA County when everybody knew about the case. Everybody knew about the criminal case. Everybody knew about the federal criminal case. And we were able to get a jury. So I think that if a judge is not squeamish about it, he can pick a jury, and it doesn't have to be. Now, on the other hand, sometimes I think it's maybe better. It doesn't trouble me that there's a change of venue if there's so much, particularly in criminal cases, much more so. I haven't seen it in civil cases, but in criminal cases, I can see that more so. But, if it's a really notorious case.
Thank you so much, Mr. Burris. And this is the person who asked the question says, thank you so much, great discussion. And this will be our last question since we only have 2 minutes more of your time. Does the movement to defund the police involve the court system and lawyers from your perspective?
Well, that is a very tough subject matter, because I don't know that there's real definition as to what defunding the police means. You can't do away with the police totally. There are issues about changing some of the funding and have less hard law enforcement activities in response, say, for example, mentally impaired people, homeless people, traffic tickets, if you will. I think you could take those funds out of there. But I will tell you this, it doesn't matter. The police unions will never give up whatever they got. So those are fights. But I do think that there should be some reorientation of policing, what police are required and should be doing, and be trained in differently. So I just think that that's a nice bullet point, if you will, defund the police. But I don't think it really goes to what you really want to get done, because you can't have a situation where there's no police. The question is, what are the police going to do? We don't want police abusing people, which they do. We want them to do that less, but not at all. So there's a lot of work to do here. But I don't think that political slogans is the way to get it done, though.
Thank you so much for that, Mr. Burris. We appreciate your time. Thank you again. We know how busy you are, so we are appreciative of your time, of your insight, and thank you to everyone that came. It is now 7 o'clock, and so we will let Mr. Burris get back to litigating the cases and, get back to work and being the icon and civil rights champion that he is. So thank you so much, Mr. Burris. We really appreciate it.
Bye-bye. Thank you.